Hello, Attorney Prashanti.
Hello.
This is about a PERM process for the green card. Will the PERM process affect if we do a location change and H1B amendment for the same employer who initiated the PERM green card process?
Right. So this is a good question. It really depends on. So the question is, um, we've the person filed a perm, but their work location changed while they were on a H1, and they have, as required by law, filed an amended petition on the H1. Now they're asking if anything needs to be done with the perm because the perm also has a work location. So the answer is it depends. It depends on how the perm was filed. If the perm was filed, looks like it's a consulting situation, I'm going to presume, because location changes occur usually in a consulting scenario. So if the perm was filed with the language that travel will be required, travel relocation to unanticipated work sites will be required, which is how it should have been filed in the and that language has to be included in the job description. If it was done that way, then it doesn't matter that you change your work location on your H1 or even for the green card, it doesn't matter because we're saying already that um, as per the PERM regulations, they have confirmed that when there is an unanticipated work location changes that can happen throughout the year, because it's a consulting position, uh, the requirement is that the employer do the advertisements from the main office of the company. So if the main office of the company is in New Jersey, and even if the person is moving around to Texas and Hawaii and Georgia, etc., they are still okay because the perm job description has said that relocation and travel is part of the job.
So now, what happens if although they have listed as various locations or unanticipated locations. Now, what happens if the main office of the petitioning employer they make a move? For example, originally it was a file for New York City. Now they move to California. However, the job on the perm listed as various unanticipated locations. So is it the base location that matters, or this language will continue and they can just keep traveling?
The base location matters. So if they change their work location to a different state outside of commutable distance, it's not like for the H1, it's not MSA, Metropolitan Statistical Area, within the same Metropolitan Statistical Area. For the perm, for the green card, it's within commuting distance. So they should be able to commute back and forth every day. If they're within commuting distance, it's fine. If they're not, then they would have to do a new advertisements, a new perm, and a new process.
So assuming they already have the 140, or they don't have the 140, assuming there's no 140, can they still retain the priority date that was originally filed?
So if you don't have an I-140, you can't retain the priority date unless um, you try to do that on the labor itself by saying that we wish to retain the original priority date. There is a question on the labor cert. I have to check and see if it's there on the new form, but it definitely was there in the old form. So there is a possibility of being able to retain that, but then you have to show that there's some terms and conditions that apply to that. It's not as simple as retaining the I-140 priority date.
Okay, so this looks pretty complex. I guess if any one of you watching this video, I'm sure you jumped into this video after searching for this question. You should definitely reach out to Attorney Prashanti Reddy, 212-354-1010, Prashanti at reddyesq.com. This definitely looks pretty complicated. If now, one last question on this topic. You just stated Hawaii and Puerto Rico are, as a standard, they're a part of this entire process with the H1B amendments and then the PERM process.
No, they don't. They don't fall under Puerto Rico. At least doesn't. Hawaii does, but Puerto Rico doesn't fall under the United States um, under one of the United States, but for other reasons they're considered to be part of the U.S., but not for immigration purposes.
But one last on this, this is definitely a crazy question. What if someone was, working for, say, some satellite company, or a, like a cruise company, or even, US government, like US Marines. They're doing a project on the ship. Now, in respect to two items here, one is about the H1B amendment, and then the PERM itself.
So, with if they are outside of the U.S., the United States immigration laws don't apply to them, so it really doesn't matter what they do at that point. If they're in the U.S. within U.S. waters, then you have to file an amended petition.
Okay. Thank you for answering that question in detail.
You're welcome.